Hello, everyone, and welcome to Uncivil Law. And for today's story, we have a spicy one from the Copyright Office, which doesn't really do spicy. It's not really their thing. The Copyright Office is a bureaucratic agency, and normally they write in fairly bureaucratic, banal terms. They don't normally go for spice, not really their MO. But they decided to depart from that practice in this case, in which they want to beat an IP lawyer to death because apparently they don't understand fair use. Exciting. That's fun. So we're going to read this. This was brought to my attention by my friend and yours, none other than Ian Runkle the Bailey, where he brought this to my attention last night on stream. And I wanted to read the rest of it because it looked super fun and exciting. So we're going to read this. This comes courtesy of the Copyright Claims Board from the United States Copyright Office in the case of Braun IP Law LLC versus Jessica Vasquez and Lily Marston. Cool. Let's read this. The claimant, Braun IP Law, initiated a copyright infringement action against the respondent, Jessica Vasquez and Lily Martin, on December the 11th of 2023. So we got an IP law firm bringing an IP issue to an IP office, namely the Copyright Office in this particular case. Should be right in their wheelhouse, right? That's what they do. That is what they do with their time. They do with the IP law. I mean, it's right in their name. Braun IP Law. Sounds like that might be their thing, man. I'm sure this is going to go super well for them. The Copyright Claim Board issued a final determination in this proceeding on January the 31st of 2025, finding for the respondents and dismissing the claim. Apparently, it didn't go very well for Braun IP. Apparently, despite being an IP-focused law firm and speaking to an IP-focused agency, it didn't really go very well for them. They lost. How sad. As a review of the final determination reveals, the case was not close. Great. Respondent use of the work at issue was a textbook example of fair use. Great. Many of the arguments made by the claimant were utterly meritless, some to the point that they undermined the claimant's credibility. Wow. That's pretty spicy language. Utterly meritless to the point that we think that you're not being credible. Wow. Things are not going very well for Braun IP Law LLC right now. Things are not going great. Moreover, the board did not take a cursory review of the work at issue and its use, but watched both works several times, detailed in its final determination factual history section, which lays out respondents' clearly transformative use for criticism and commentary. Yeah, it's like our review wasn't cursory. We actually looked at both works, the underlying work and the supposedly infringing work. We looked at both a couple times, as we've already told you about, and it is not close. It's clearly fair use, textbook example. This is the example in the encyclopedia. Holy shit. This is going great. Despite the detailed nature of final determination on March the 2nd, 2025, claimant filed a request for reconsideration. A request for reconsideration of final determination must identify a clear error of law or fact that was material to the outcome or a technical mistake. Yeah, that's what that's for, right? A request for reconsideration is, oh, geez, no, you made a huge error. Like that. It's like not like I just disagree with your reasoning. It's like, oh, you forgot some critical case, or you forgot some really important piece of evidence. Like you made a fundamental mistake somewhere along the line. It's not just I get another go. It's like, so you have to identify, oh, you forgot this critical fact, or you forgot this critical case, or something like that. That's what a request for reconsideration is for, not just I don't like the result, yo. Right? It's like, no, that's not what it's for. Just as importantly, the request shall not merely repeat any oral or written argument made to the board as part of its proceeding, but shall be specific as to the purported error or technical mistake that's the subject of the request. That's how that's supposed to work. Notwithstanding that rule, the request is simply a 12-page brief rehashing the greatest hits of the party statements claimant filed in the written testimony phase. Ouch. Rehashing the greatest hits? I didn't know that the Copyright Office knew what sarcasm was. They're not normally known for being super fun-loving guys, man. They're not normally known for being the sarcasm crew. When did the Copyright Office get some people who speak sarcasm? Because it's dripping off the page, man. Holy shit, man. They don't like you, man. This is horrible. For the Copyright Office, this is just getting beaten to death, man. Jeez, Lord. The board could simply deny a request on that basis. The arguments continue to be meritless. That's definitely what you want to hear as an attorney, let me tell you what. And no clear error of law or fact or technical mistake is presented. However, rather than merely denying the request in a cursory order, which we totally could do, the board will briefly hash why the episode so obviously qualifies for fair use. So we are completely within our rights here because we already gave you a full hearing. We've already given you due process. We're fully within our rights to be like, there's nothing new here, go away. But we're not going to do that. We're actually going to go out of our way to take time out of our day to write some more verbiage about how you suck. Wow. The copyright board does not like you, man. They are not feeling it, man. Factual history. For a more detailed factual history, including the many ways in which the alleged infringing work uses claimant's work to criticize it, see the final determination. Suffice it to say here, the entirety of claimant's work depicts Braun's IP's owner, Jeanette Braun, sitting at her desk, recording on a computer or phone camera a generally factual recitation of her position in a dispute with an internet personality named Becca Day, which arguably could potentially make it a thinner copyright technically as well. So if the copyright is a purely factual work, and the quintessential example would be the phone book, right? So a phone book would be a good example, right? Because it's a purely factual work. There's not much creative in it. We'll get to that in a second. But like fundamentally, the phone book is just a list of names and phone numbers, right? And there's no creativity in that because those are just those people's names and their phone numbers, right? So there's no creativity in the underlying factual information. You can't copyright facts. You can't copyright facts. Although you can copy groups of facts, or you can copyright a collection of facts. But the more strictly factual it is in its nature, and the less creative it is, you get what's called a thinner copyright. And you can see that actually in the case law. They talk about thin copyright. So it's like you got copyright, but it's not very much, because the only copyright you have is to the creative elements, which in the case of a phone book, again, is not very much. So there is some creative element there, but not very much. So you don't get really a lot of copyright protection, as opposed to a work of pure fiction where I'm just creating it off my head, right? In my head, it's just a work of fantasy. Then that would be entitled to maximum copyright protection, and of course, you can be somewhere in between. So if what she's doing is merely sitting at her desk, recording on a computer or phone, her position in a dispute, that could arguably be closer to the factual dichotomy than not. So that's sort of an interesting technical point with how much copyright does she really have in the first place. Not that it appears to matter here, but it's just interesting. So we'll discuss it for a second. Anyways, Braun did not like that Day accused Braun of filing false copyright strikes against small creators, such as podcasters and influencers on the internet, so that she can get things her client likes do not take down. Braun's defense to Day's accusations in the work is highly semantic, that she does not file a copyright strike, but rather files a request for a strike, and the online provider performs the strike. That is a very, very technical distinction. And as I would say in law, this is what we are doing is we're trying to slice it awfully thin. It's like we're trying to slice this very, very thin. And unfortunately, you're slicing it so thin, I can see through it, right? It's so thin, it's transparent. So there's not real, so it's like, oh, this is not the same thing. And I'm like, I don't know, man. I don't know. It might be the same thing. It's like, I didn't file the strike. I merely filed a request to strike. It's like, I'm not sure that I see the distinction between those two things, but you do you, I guess. Yeah. A distinction without a difference, as some people might say. The TN drama referred to in the work was squarely in the wheelhouse of Respondent's podcast. In the course of discussing the Day-Braun fight and Braun's position related to that dispute, Respondent played a 1-minute clip from an 8.5-minute work, promising on our fair use analysis, right? One of the factors is the amount of the work taken. So promising for a fair use analysis, we only took 1 minute of 8.5. Sounds like we tailored our use to use less instead of more. That's promising for fair use. And spent approximately an hour commenting on and critiquing it. Also pretty promising, right? We're commenting and critique, which is within the preamble of the Copyright Act, and we've certainly transformed it by providing critique there too. So it's like, oh, we used 8 minutes for an hour's discussion. That sounds pretty like it's leaning more in the fair use discussion. That sounds promising. All right. Completely dismantling all of Braun's argument in the work, as well expressing their displeasure with Braun's tactics. So it's like, oh, I showed exactly what she said. She's making this argument. And then I basically went for it line by line or point by point, basically. And I'm like, no, I don't agree. Let me tell you why I don't agree. And also, I think you're dumb. Sounds fair use-ish. Sounds fair use, right? It's like, here's what you said. Here's my response. I don't agree. You're an idiot. Sounds pretty fair use. Response also discussed at length the concept of fair use and allegedly argued that Braun engages in hypocrisy by sending down takedown notices against instances of fair use and material potentially not protected by copyright, even though she has previously educated the public in other videos that she's published that fair use analysis should be made before sending a takedown notice, which, at least in the Ninth Circuit, that's what that case said. So, wouldn't be necessarily the worst idea to do a fair use analysis before sending a takedown notice. Wouldn't necessarily bad. Required in the Ninth Circuit, not necessarily a bad idea in other jurisdictions either. All right. On December the 3rd of 2023, Braun IP sent a takedown notice to YouTube regarding the episode, and respondents sent YouTube a counter notice. As previously noted, YouTube's opinion does not factor into the board's decision because, of course, it does. YouTube is not the Copyright Office. They're not a legal entity in this context. They're just like, here's what we think. If you want to go, if you want to continue suing each other, you can take it to court. That's fine. So, that's fine. But YouTube's going to try to adjudicate as best they can. But what they think doesn't matter. They have no legal impact on these issues. They're not a court. So, yeah, obviously. But YouTube unilaterally made the decision that regardless of whether Braun IP filed a copyright lawsuit concerning the episode, they would not take the episode down because YouTube independently determined that the episode's use of the work clearly fell within the category of fair use. Which, fair enough. Fair enough. We're not going to do it unless you make us. Cool. Thank you, YouTube, I guess, for standing up for that. That's nice. And, if YouTube got it wrong, you can absolutely go sue her in court, and then the court can be like, silly YouTube, I don't know what they were thinking. I'm not sure why they thought you fair use. This is clearly not fair use. Silly person, take it down. And YouTube would follow that court order, but they're not going to do it unless they get a court order because they think they don't agree. So it's like, okay, fair enough, pressing on. Related to potential damages and market harm, Braun IP stated that a standard licensing agreement for video it creates, for which it charges $7,500, and attached two sample licensing agreements. Well, that only matters if I need a license. But if it's fair use, I don't need a license. I don't need your permission. That's the thing. So I didn't get a license. So let's try something else. It was unclear what types of videos the license covered and where those videos were anything like the work, although Braun IP now admits the licenses were for very different types of videos, as the work was an outlier to Braun IP's typical material. Okay, I mean, you offer licenses, that's nice, but do I even need your permission though? All right, as to fair use, rather than trying to identify a specific clear error of law, which would be helpful, the request is dedicated to re-arguing the fair use principle, including the first, third, and fourth factors. It's like, we already looked at these factors in our prior decision, man. We already looked at it, okay? We're done. Again, it would be easy for the board to deny the request on that basis alone, since every point made by claimant was already made by her in her party statements. We gave you due process. We gave you the process that was due. We gave you a hearing. We considered your case, and we found it wanting, severely so. So we don't have to do anything more. However, we're going to anyway. It'll briefly explain the fair use factors with the hope that Braun IP might change its tactics in the future. Lol. When did the copyright board get fun people? When did they get fun people at the copyright board who know how to speak sarcasm? This is great. Four non-exclusive factors are considered when analyzing fair use. It sure is. The purpose and character of the use, including whether such use is of commercial nature or is nonprofit educational purposes. The nature of the copyrighted work. And this, by the way, this speaks to the fact-fantasy distinction. So this is what they're talking about when they talk about the nature of the copyrighted work. They're talking about, is this merely fact? Is it pure fact, in which, no copyright at all? Is it fact in some sort of assembly, in which case it might be a looser copyright or a weaker copyright? Or is it like a pure work of fiction, in which case a maximum copyright? So this, how much of it is factual in nature versus how much of it is creative in nature, that's what element 2 is speaking about when they talk about the nature of the work. The amount and substantiality of the portion used in relation to the copyright work as a whole, how much did we use, and the effect upon the potential market for or the value of the copyright work. Fair enough. We all know those factors. See, for example, 17 USC and some cases, but whatever, that's just in the statute. We could just stick with that. Okay, as to the first factor, the claimant, which once again is an IP law firm, misunderstands the esteem that critique and commentary explicitly called out in section 107 holds in the fair use analysis. They misunderstand the esteem. Nice. Yeah, I mean, it's in the preamble, by the way, to 17 USC 107. It's in the preamble, like education, critique, criticism. It's in the preamble. So those purposes are held with a particular loftiness because the statute says so. So you misunderstand that we actually think that critique and criticism is a valid thing. Lol. Braun IP argues the commercial nature of the podcast outweighs the transformative work, which, okay. But the fact the podcast was commercial carries little weight when the purpose of the use was the critique of the work. Yeah. I mean, it's like, well, it's commercial in nature, I suppose, maybe, I guess. But that's only one factor and also doesn't speak to the factor we're discussing right now. So there's that. Okay, great. As the Supreme Court has said, the commercial or nonprofit educational purpose of a work is only one element of the first factor inquiry into its purpose and character. And if commercial carried presumptive force against finding a fairness, the presumption would swallow nearly all the illustrative uses in the preamble, including news reporting, comment, criticism, teaching, scholarship, and research, since these activities are generally conducted for profit. So yes, I'm trying to make money from it. That's true. But the law says I'm allowed to make money from it if I'm doing it for these reasons. And, other stuff. But for these reasons, it's like, yeah. So I appreciate it's commercial, maybe, but that only gets you so far. There is no doubt that defining that copying was not commercial in nature tips the scales in favor of fair use. So if it's not commercial, that helps. But the inverse is not necessarily true, as many common fair uses are indisputably commercial. For instance, the text of 107 includes examples like news reporting, which is often done for commercial profit. So if it was non-commercial in nature, that helps with the fair use, but the reverse is not necessarily true. Okay. Claimant quotes the syllabus as opposed to the actual decision in Andy Warhol Foundation. Wow. Wow, what a thing, man. All right, so the US Supreme Court provides a summary of the case at the top of the case. They call it a syllabus. That's not part of the decision, as, by the way, the Supreme Court makes clear literally every single time they publish it. There's a line in there basically saying this summary has been provided by the clerks and does not form part of the case. It is merely there for the convenience of the reader. So you shouldn't quote from the syllabus because it's not part of the decision. It's a summary of the decision written by the clerks. They do a really good job. It's an accurate summary, but just quote from the decision itself. Don't quote from the syllabus. What an amateur move, man. What an amateur move. That's not great. For the proposition that when secondary use is transformative to some extent, the first factor can still weigh against fair use when the transformative elements are outweighed by other factors, such as the use's commercial nature. It can. However, the Warhol opinion noted that criticism and commentary for the purposes of respondents' use of video clip are the sorts of copying the courts and Congress most commonly have found to be fair uses, and so may guide the first factor inquiry. So the Supreme Court, what they did in Warhol essentially is they rebalanced the four elements, essentially is what happened in Warhol. Transformative use had been for 20 years, probably, if not a little bit longer, basically the thing, right? So transformative use had gotten to the point where it kind of wiped out all the other factors, right? And the courts were just kind of looking to transformative use. If they found transformative use, they kind of were done. And so basically what happened in Warhol, in so many words, is the Supreme Court said, well, no, commercial use is still a thing. And so they didn't necessarily say like commercial is more important than transformative, but they definitely reinvigorated commerciality as an element of at least, let's say, roughly equal station to transformative. So before, where the courts would just say, well, this is transformative, commercial doesn't matter, the Supreme Court now is basically saying, in so many words, you can't quite do that. You have to consider it with a bit more nuance. Incidentally, I think one of the reasons they were doing it, although they never said this in Andy Warhol at all, but this is just conjecture on my part, I think one of the reasons they said it is because they're thinking ahead towards the time when they're going to be asked about all these artificial intelligence systems that are being developed that are using copyrighted works to develop their algorithms. Because if it was just transformative, if transformative was the end, I would have said, and in fact did say on record, on stream, before Andy Warhol, I would have said that, hey, these are transformative. Like ChatGPT might be using all this copyrighted work, but it's transformative. I don't really have a problem with that. And I think one of the reasons they said what they said is because they're thinking ahead to those cases and wanting to give themselves a little bit more latitude to say the commerciality might be a bigger factor and perhaps provide a little bit more caution to the courts below as they're considering the fair use analysis of ChatGPT and other AI large language models. Again, pure speculation on my part. None of that was mentioned in the case, but I think that might have been part of the reason they said what they said. But, that's what it is. All right. Anyways, continue on. The court also noted that commentary or criticism that targets an original work may have compelling reason to conjure up the original by borrowing from it, which is often true, right? It's like, in order to provide a sufficient critique, it really helps to be able to quote or reference the original. So that's right. Respondents' use of claimant's film clip was precisely for the purpose of commentary and criticism targeting claimant's work, and therefore highly transformative. And then they quote Nimmer on copyrights, which is probably the foremost treatise on copyright law. So Nimmer on copyrights is probably the leading treatise on copyright law, and which says, consider the nearly universal recognition of fair use in connection with functions of criticism and review. Here it's permissible to quote substantial passages precisely because the review supplements, but does not replace the functional work being reviewed. Sounds right. In short, respondents' use was not merely transformative to some extent. It's precisely the type of highly transformative use that is fair even when done for profit. Fair. Braun also raises a strange argument. Again, the Copyright Office doesn't normally use this kind of vernacular. The Copyright Board is pissed. The Copyright Board is pissed. Braun also raises a strange argument while citing some of the cases finding fair use already cited by the board, that the episode recreated the work's creative expression. As already stated by the board, respondents used the 1-minute clip to accurately report on the story they were discussing and allow their viewers to understand the context of the story and their critiques of Braun and of the specific content in the clip. The recreation argument is just a different way of stating Braun IP's meritless, and there's that word again, meritless, argument in prior written testimony that the clip was used for its original purpose, which was to provide Jeanette Braun and Braun IP law side of an online dispute between her and another online content creator. Well, no, it was meant to provide a response to that perspective. That's why they did it. They didn't do it just to restate your opinion. They did it to show your opinion, and show exactly what you said, and then critique it. So, yeah, that's a little bit different. This is great. As stated in the final determination, respondents' use was for the opposite purpose of any possible creative expression in the work, to go through a detailed critique of Braun's content and give reasons why Braun's side of the story did not hold water. There is no doubt this use falls in the category of criticism and commentary. Right. Braun IP does not seem to have learned a basic lesson from the cases cited by the board. When one video is used to present the point of view and a second video uses the first to criticize that position, the use is fundamentally at odds with the original purpose of the first work and therefore inherently transformative. Yeah, you said our position is great, and the entire point of our video is to say your position sucks. So that kind of transforms it from what it was supposed to be. A little bit. As Braun IP does not challenge the board's finding on the second factor, including that where a work is used to critique that specific work, this factor is of little relevance, the board moves on to the factor 3, the amount and substantiality of the work taken. On this third factor, the request is certainly no more of a rehashing of claimant's prior argument, rejected by the board, that the heart of the work was taken. Now, to give Braun IP what little credit they deserve on this issue, heart of the work is a factor in the analysis. So if I only take 1% of your work, but that work is the heart of the work, it's the most important work, most important thing, right? So if I take the most important thing, then the fact that maybe it's only 1% of the work, it doesn't matter as much, right? It wasn't just any random 1%, it's the heart of the work. And again, there's case law on this point. So she's not like without merit to say, okay, just because it's a relatively small percentage isn't necessarily dispositive. It's not a pure percentage thing. She's right, it's not. If what I took is the most important thing, essentially it counts more. That's correct. So the heart of the work is definitely an argument that can be made, but the Copyright Board didn't really buy it, and they gave it consideration. They were like, we don't really feel it, ma'am. We don't feel it. Braun IP does not dispute the board's finding that a small amount of the work was taken. Respondent took only 1 minute of 8.5-minute video, which amounts to approximately 11 to 12% of the work, and makes up approximately 1 to 2% of the episode which responds to it. However, Braun IP suggests that unless respondents could affirmatively prove that the portion taken was not the heart of the work, which is definitely not how that works, you're the one making the claim. You're the one making the claim, so you're the one that has the burden of proof. I mean, that's pretty simple. We know that, right? The person who's making the claim has the burden of proof. Is it on them to prove that it's not the heart of the work? Not really. It's kind of on you to prove it's the heart of the work because you're the one making the claim. So, yeah, that's not a thing. The board should take claimant's argument as fact, even if there's no evidence to support it, which also doesn't really make sense. So, like, even if, like, it was on them, it would be really helpful, even if they had a duty to rebut it, which they would, I suppose, if they made the claim in the first place. But it would be really helpful if you gave us some reasons why it's the heart of the work, and not so much with that, so not really. In doing so, Braun IP cites cases not dealing with criticism and where plaintiff actually proved what was taken was the heart of the work. So again, that is a thing that can happen. It has been known to law. So there have been times when courts or other organizations have said this is the heart of the work. That's true, but it doesn't mean it's true for you. This is preposterous. Again, this is really, they're really not buying your legal theory, man. They're not really buying this. As his claimant seemingly suggests this factor must always go against finding fair use by arguing the mere fact respondents chose this portion of the work to critique it is prima facie evidence that these clips were the most important moments of the work. That's an interesting argument. That's an interesting argument. So the mere fact that that's what you responded to means inherently it must be the most important. I mean, I guess that's something. Again, claimant only serves to undermine his credibility by making such arguments. Holy shit. Low. As discussed in the final determination, respondent used the work to provide context so they could properly critique it, using no more than was reasonable and limiting their work to specific parts they were criticizing. By the way, Jeanette, if you're out there, before you get copyright happy, I'd just like to kindly remind you that this document was produced by the US government, and therefore there is no copyright in it at all under 17 USC 105. So before you try to say I infringed a copyright, no, because there's no copyright. Great, moving on. Finally, the request fares no better as factor 4. As an initial point, the request assumes the board's finding. The respondent's use was transformative and use for criticism and commentary was incorrect. It was not. And claimant has clearly shown no error of law. Nice. The request seems to, in order to re-argue that claimant and respondents were competitors and respondents usurped claimant's market for the work, admit the work was an outlier from Braun's IP typical videos about copyright law in general. Well, maybe it's an outlier in so much as hopefully, as an IP law firm, hopefully the rest of their videos are providing good legal advice, but I wouldn't necessarily take it as a given. Regardless, as stated in the final determination, as not challenged by Braun IP in the request, Braun IP presents no meaningful evidence that respondents' use of the work affected the market or value of the work. And with this admission, the licenses Braun IP presented with its written testimony go from practically meaningless to absolutely meaningless. Get wrecked. Get wrecked. Wow. Respondents took a small portion of the work to criticize its content, full stop. As stated in the final determination, there is no rational argument here that claimant and responders were competitors, or that use of a small portion of the work to criticize Braun and her position in the Day-Braun dispute would have replaced any possible market Braun had for the work and thus acted as a substitute for the original. Wow. In sum, Braun IP, which promotes itself as a law firm knowledgeable about and experienced in intellectual property law, holy shit, has not presented any argument that would amount to an error of law, never mind a clear one or one material to a final determination. The request for reconsideration is denied. Your friends at the Copyright Claims Board. Wow. Wow. That is spicy bureaucrat. That is incredibly spicy bureaucrat. Wow. They must really, really hate you. They must really, really hate you a lot. They must think that your argument is so dumb they've lost IQ points. Like what you've said is one of the most idiotic things we've heard. At no point in your rambling, incoherent statement were you even close to a rational thought. I award you no points, and may God have mercy on your soul. Basically, that's what this said. Holy shit, man. Man, it's like, wow, that's rough. If I'm Braun IP, I want to crawl into a hole and die. That's what I want to do right now. I don't think yeah. It's so Braun IP, the IP specialist law firm, lost against a couple pro se's at the Copyright Office. And not only did they lose, they got their teeth absolutely kicked in. Great. That's amazing. That's fantastic. So yeah, maybe don't hire Braun IP Law LLC for your intellectual property needs. I'm not necessarily sure they're necessarily the best at the IP law. Maybe try to find somebody else. I don't know. So that was fun. So I guess I'm going to go ahead and sign off for now because I don't really have anything more to say about this case. This has been fun. Thank you, Rogue USAID employee, for being a member of 13 months. And thank you, Ian BPPK, for being a member for 32 months. We do appreciate your continuing support. I've been on Civil Law. Until later, my friends, I hope all is well. Cheers for now, my friends, and goodbye.